Welcome. My name is Erwin Chemerinsky, very fortunate to be the Dean of Berkeley Law, and I welcome you to this important event. Like all of us, I watched with horror as Russia invaded Ukraine. Wondered if what I felt was what people in the United States thought as they watched Germany invade Poland in 1939. A mixture of horror, revulsion, fear, and helplessness. We are a law school, and it's important for us to look at the legal issues that surround Russia's invasion of Ukraine. At the outset, I want to take a moment to express compassion and support for our students, staff, and faculty who are from the Ukraine and our family members who are there. I also want to take a moment at the outset to express gratitude towards the Miller Center, Tony Mendocino, Laura Fletcher, Katerina Linos, to Berkeley AV and Event Services, and especially Jenny Boyden for pulling this program together on such short notice. I want to introduce for you the speakers in this program. I'm going to give very short introductions so the time can be spent listening to them. The moderator for the program is Professor Katerina Linos. She's the Irving G. and Eleanor D. Tragan Professor of Law, and she's the co-director of the Miller Center for Global Challenges in the Law. The first speaker who you'll hear from is Tess Bridgeman. She teaches national security law at Berkeley Law. She's co-editor-in-chief of a very important blog called Just Security, and she recently served as deputy legal advisor to the National Security Council. You'll then hear from my colleague, Professor Sarah Mohammed, who's an expert on international law, and particularly the law of war and mass atrocities. You'll then hear from Elena Chachko. She's a Miller Center postdoctoral fellow, and this fall she'll be an assistant professor at Hebrew University. And then you will hear from Lindsay Freeman. You'll then hear from Lindsay Freeman, who's from Berkeley's Human Rights Center. And the Human Rights Center is a leading program in the country, in the world, especially with regard to digital information and disinformation and the use of digital evidence in international prosecutions. I thank all of you for watching this important program.
Thank you so much for that introduction and to the organizers of this event. It is an incredibly important and thorny set of issues, and I'm glad to be able to speak with my co-panelists about them today. So I was asked today to address primarily accountability for Russia's unlawful actions and some of the domestic law issues that might arise with respect to a potential U.S. response. But first, just to contextualize these events a little bit, as we all know, what Putin is betting on here with this invasion of Russia and other suite of incredibly provocative actions is democratic decline. So it's what we do now that proves him wrong or not. And this crisis, of course, comes at a time when our own democracy has had a troubling few years. The health of our democracy is not, I think, what it used to be by all accounts. Just over the past few years, we've weathered a norms-busting presidential administration that left the country badly fractured. Which culminated, of course, in the attempted insurrection on January 6th. That one of our two major political parties has called normal political discourse. We have a persistent pandemic made worse by political divides. So with Russia's invasion of Ukraine raising existential questions about the global international legal order, the strength and stability of our own democratic institutions are being tested, and they're arguably much more important than ever. They are a bulwark against domestic authoritarianism, but also international authoritarianism. And we can talk about why today. So rallying our partners to do things like impose far-reaching sanctions and export controls, expelling Russian banks from the SWIFT payment system, blocking the Russian central bank, which is an incredibly major step, providing lethal weapons shipments to Ukraine, even on the part of our European partners who hadn't done so in the past, ousting Russian airlines from European airspace. These are responses that won't necessarily be cost-free for ourselves. And near simultaneous rollout of many of these responses have really demonstrated unity and resolve, commonality of purpose. these are only possible when acting from a position of legal and moral strength. So democracies rallying together to impose these kinds of costs on Russia hopefully can help be a form of strengthening our own democratic institutions and the unity of democratic governments in the face of rising authoritarianism, exemplified by this Russian invasion, but certainly not the only example of it that we face right now. So what is a democracy to do? I'll briefly touch on three categories of potential responses, some of which we're already seeing play out. Naming and shaming consequences and diplomatic isolation is one category. Another is raising the material costs to Russia. And a third is affirmative steps to counter their aggression. So none of these, of course, will be a silver bullet. None of them will work overnight. The goal over time is that in combination, these types of actions can deny Russia's ability to sustain its unlawful invasion and can build an international bulwark against future aggression by Russia or other states who would be poised to take similar actions. So number one, naming and shaming actions and diplomatic isolation. These are things like visa bans, which will be more effective if they're implemented as broadly as possible across jurisdictions where the targeted individuals want to travel or reside. Ideally are accompanied by asset freezes. And these being imposed against Putin, his close associates, Russian legislators who voted to authorize Putin's use of military force in Ukraine, other relevant Russian officials, show the degree of stigmatization of these actions and that those who are involved in, who are complicit in these actions are not welcome in other states. Second, releasing information on corruption and money laundering on the part of those same individuals. Diplomatic isolation can take many forms, the strongest of which could be recalling diplomats and expelling Russia's diplomats reciprocally, suspending their privileges in certain international organizations. And the point with all of these actions, right, is to make clear that Russia's invasion is not restoring its former glory, quite to the contrary. These are the actions that make you a pariah state. But the point is not to cut off all communication, right? Crucially, it's important to maintain hotlines for communication and open channels that can be used to de-escalate and to avoid miscalculations. So a second bucket, raising the material costs on Russia. We've seen a fairly incredible ramp up of economic sanctions and export controls just over the past several days. These measures are the ones a lot of people are talking about that are hopefully going to be highly impactful over time. Again, these are not silver bullets that are going to work overnight. And it's also important to recognize that these are actions that have a high likelihood of impacting the Russian people. In fact, some of them, that is their design, but also having repercussions for the global economy. We could soon see grain shortages in the Middle East. These are actions that have the potential to be destabilizing, if not calibrated and accompanied by assistance to backfill for what's been cut off, for example. So it's important to keep in mind when raising material costs, again, that engaging in effective diplomacy and keeping in mind the humanitarian consequences is going to be necessary in the design of these kinds of programs. And third, this is kind of the most consequential bucket, likely to have the biggest near-term impact, but also the most dangerous and escalatory, are affirmative steps to counter Russia's aggression. Many of these actually can reside in the kind of non-military domain. So things like shutting down Russia's disinformation operations. And I think one of my co-panelists will talk more about potential cyber operations below the threshold of the use of force. We've seen the EU already ban RT and Sputnik just recently. These kinds of steps could be highly effective in ensuring that the facts from the free press are what the international community and hopefully even the Russian people to some extent are able to see, as opposed to just the Russian disinformation and misinformation campaigns that they're very effective at. Things like closing off airspace to Russian overflight fall in this category, remotely assisting Ukraine with maintaining its own critical infrastructure to the greatest extent possible. Providing massive humanitarian support to Ukraine is going to be critical, and it's going to be really helpful. It's going to be crucial not only within Ukraine's borders, but also with respect to the refugee flows that we'll see across Ukraine's borders that have already begun. And again, one of my co-panelists will speak more about that. But then we get into the most controversial set of steps, of affirmative steps to counter Russia's aggression. And this is where we start to get into some of the domestic law issues that I'll touch on. Providing military support can come in many forms. And I think it's often assumed that when we talk about military support, we're talking about, a no-fly zone, or, the U.S. Engaging directly in use of force against the Russian invasion. That's not what's on the table right now. And President Biden has made that really clear. We'll get into that more in a second. But there are a number of things that the US has already done, that our European partners are starting to do, that can be incredibly important, like selling defensive weapons, logistical support, certain types of intelligence support that don't amount to using force against Russia. These are the kinds of actions that the US engages in on a regular basis when it comes to conflicts against non-state actors within a state that's facing a civil war. Much less often are we called upon to do that in the interstate context, but that's what's necessary here, and it's what the Biden administration has already been doing. But going further than that, we start to get into big difficulties. So just to make a kind of a clear baseline here, and as I just alluded to, President Biden has made clear repeatedly that he has no intention of deploying U.S. forces to directly fight Russia. Right? No one wants a shooting war between two major nuclear powers. That is not a good idea. Some have argued, though, that what we're already doing vis-a-vis Ukraine in terms of defensive support crosses certain legal lines. So let's unpack a couple of those. So first, you've seen some arguing that the announced troop deployments to Eastern Europe, to NATO's eastern flank, trigger the War Powers Resolution's requirement that the president report within 48 hours and then withdraw within 60 days, absent congressional authorization, any forces that are deployed into hostilities or into situations where imminent involvement in hostilities is clearly indicated by the circumstances. That's a crucial part of the War Powers Resolution that is designed to ensure no unauthorized wars are waged without Congress having an opportunity to weigh in. But the deployment of additional U.S. forces to NATO members in Eastern Europe does not constitute the introduction of U.S. forces into hostilities, or even into a situation where imminent involvement in hostilities is clearly indicated by the circumstances, which the executive branch has interpreted for decades to essentially mean U.S. forces are going to get into a shooting war, or there's going to be a high likelihood of escalation such that U.S. forces would be giving and receiving fire. That's not what we're seeing here, at least not based on the facts on the ground right now. So a different question arises, though, if an actual NATO member is attacked. And that is, of course, part of the point of deploying forces to the eastern flank, is to deter that kind of attack, to show unity and resolve, and to ensure that there's not a miscalculation there on Putin's part. But what if a NATO member is attacked? There is, in fact, contrary to what some believe, significant discretion in how the Biden administration could respond, how the United States could respond. So there's, I think, a fairly pervasive misunderstanding that Article 5 of the North Atlantic Treaty, which is the collective security teeth of the NATO alliance, that it requires the United States to use force in response to an attack on another NATO member. The United States would certainly be able to use force in response in that kind of situation, but in fact is not required to do so. So the North Atlantic Treaty provides, right, in pertinent part, an armed attack against one or more of the parties shall be considered an armed attack against them all, and then goes on to say that the parties individually and in concert with each other will take such action as it deems necessary, including the use of armed force, to restore and maintain the security of the North Atlantic area. So while Article 5 does require NATO member states to consult and provide assistance to each other in the event of an armed attack, it leaves to each individual member the decision as to the nature of that assistance. And Article 11 of the treaty further states that the provisions of that instrument shall be carried out by the parties in accordance with their respective constitutional processes. So what does this mean? It means that NATO members will follow their own domestic law processes for authorizing the use of military force. In our system, that means that the president would go to Congress to ask for authorization. Again, there is a matter of degree here in terms of what the U.S. response is. If it's a response short of force, the president may not need to go to Congress for further authorization. But before getting into a shooting war with Russia, even in the circumstance where a NATO member is attacked, it's not the case that NATO Article 5 requires a U.S. Response that amounts to the use of force. And it's not the case that would need to bypass Congress, even if the U.S. decides to act that way. Likewise, there's been some confusion about whether NATO's Article 5 itself provides domestic legal authority for the president to use force in collective self-defense. That's also not the case. So the War Powers Resolution in Section 8A, in fact, made explicitly clear, essentially, that the treaty power cannot be used as an end run around Article 1 of the Constitution, which gives the power to Congress to decide when to take the nation to war. So how Biden would respond in that kind of a situation is very much something that would be a decision in open dialogue with Congress, and that could, if push comes to shove, require congressional authorization to use force. But again, I'll reiterate, no one wants to be in that position. Biden is not planning on taking us into that position with any of his actions. Right? The overall goal that we've seen so far, and I think this was exemplified recently, just over the last 24 hours, in the response to Russia's putting its nuclear forces on alert. The overall goal here is de-escalation, is solving the conflict through peaceful means, is trying to avert any unnecessary suffering on the part of the Ukrainian people, the Russian people, others in their neighborhood, and globally, that could be averted if this conflict can be de-escalated. The big question then is, can we find off-ramps for Putin? Even if we do, will he take them? So it's hard to see, unfortunately, right now, what a mutually agreeable solution will look like. It's hard to see what kinds of hard compromises each side would be willing to make. But that's the type of solution that is clearly in the national security interest of the United States and all states involved, and in fact, for the broader global community. So I've hopefully given us a few issues that we can come back to in Q&A and issues that others can pick up on in the panel. I'm looking forward to hearing what my co-panelists have to contribute and to our discussion. Thanks very much.
Thank you. We'll now turn to Professor Sarah Mohammed, who will address the international law prohibition on the use of military force and Russia's purported justifications, and we'll open for questions after each of the four panelists have spoken.
Hi, everybody. Thank you all for being here today, and thanks so much to the organizers of this event, especially Professor Linos and the amazing Tony Mendocino and Jenny Boyden for coordinating this on very short notice. And I want to extend my thoughts to those in our community who have roots and homes and loved ones in Ukraine. I'm grateful to be with you all today to get to talk to you about the many international law issues related to this invasion. I'm going to focus primarily on the international law prohibitions on the use of force and why international law matters here, even if not as a direct constraint on state or individual behavior. Can we advance to the next slide? So I'm going to focus really on the prohibition against the use of military force in two ways. The first is the prohibition as it applies against states. States is what we call countries in international law. And then later I'll talk a little bit about this prohibition as it applies against individuals. Advance slide. Okay, so I'm going to start with some basics. I'm assuming that some in here at least are not familiar with international law, so this is going to be a little bit of a primer and also a focus on our current events. So under international law, states are prohibited from using or even threatening the use of military force against other states. This prohibition is codified in the UN Charter in Article 2.4, which is up on the slide. The UN Charter is a treaty that sets out obligations for UN member states, but this prohibition against the use of military force extends even beyond the UN Charter. It's a prohibition that exists also in what's called customary international law, which is a body of unwritten rules that apply to all states, regardless of UN membership. And it's considered a jus cogens prohibition under international law, which means it's sort of at the top of the hierarchy of rules of international law. There's no way to derogate from it, either through treaty making or launching your objection to it, which is one way of derogating from international law rules in customary international law. This prohibition on the use of force, which was enshrined in the UN Charter, is really the central rule of international law. And when it was written into the UN Charter, it represented not just a rule on the use of force, but really it represented a change in the nature of military force, a shift from an acceptance of the use of military force as an instrument of foreign policy to an expectation that military force must not be used in that way. And it's a change in the character of military force from this instrument of foreign policy to an instrument that's supposed to be only used in the common good. And consistent with that spirit, there's only two situations under international law in which military force is permissible. Next slide. The first is when the UN Security Council authorizes the use of military force. So I'm going to talk a little bit more about the UN Security Council in a couple of minutes, but the UN Security Council can authorize its members to use military force against another state. The second exception, onto the next slide. The second exception is for self-defense, which will be up here now. Article 51 codifies the right of all states to use military force in self-defense. If a state is attacked, other states also may participate in its self-defense. That's known as collective self-defense. Now, Ukraine has a right to use military force in self-defense against the invasion by Russia. That is absolutely clear under Article 51. But Article 51 has been invoked not only as the justification for Ukraine's use of force, but Russia has actually tried to justify its own use of force against Ukraine as an exercise of self-defense. So Russia has offered up a couple of different justifications under international law for its use of force. It has primarily claimed that it is using force in self-defense, and that this is self-defense through collective self-defense as articulated through the recognition of Donetsk and Luhansk as independent republics. So he said that there are now independent republics in Ukraine that can defend themselves against Ukrainian aggression, that Russia can participate in this operation as an exercise of self-defense. There is no question that this is absolutely a nonsense claim, right? That these are not independent countries. Russia cannot recognize these as independent countries consistent with international law. So the very sort of claim that these are independent countries itself is inconsistent with international law. Putin has also articulated something of a humanitarian intervention type claim in justifying the invasion. So humanitarian intervention refers to the use of military force to protect human rights. And so he has argued that there are Russians experiencing human rights violations in these regions, and that because of that, Russia can use military force to protect them. That too has no basis in international law. Humanitarian intervention is a justification for military force that has been debated for a long time under international law. The overwhelming consensus in the international community is that it is not permissible under international law unless we're talking about a use of force that's been authorized by the UN Security Council. So even if there were human rights violations taking place, that would still not be a basis for a justification. But it's noteworthy nonetheless. Why is it noteworthy? Well, for one thing, it is notable that the justifications that Russia has put forward for this invasion are grounded in the language of international law. The claim has not been we are invading Ukraine because we want to. The claim has been we are invading Ukraine because we are permitted to do so under international law, indeed perhaps even obligated to do so under international law. Putin has also called attention in putting forward these justifications to violations of international law on the use of force by the West over the last many years. So there's been some kind of both sidesism here, the references to the many times, indeed, when this prohibition on the use of force has been violated over the last many years are important. The fact that those violations have occurred, indeed, right? We can just look at the Iraq War of the 2000s. The fact that those violations have occurred, it doesn't actually mean that the prohibition against the use of force under international law has disintegrated or vanished. The fact is that the treaty prohibition on the use of military force remains in the UN Charter. And with the way that international law works, the response to the violation is quite important. So the fact that the violation occurs, of course, is important to the integrity of the rule. But a clear, loud condemnation of violations of the rule is really crucial for the integrity of the rule too. And so the responses that are coming out of individual states and also the United Nations are very important for maintaining the integrity of that rule. I'm going to turn next to what can possibly be done about this very clear violation of the prohibition of the use of force. Next slide. So in the vision of the UN Charter, what should normally happen in a situation when one country invades another is that there is a resolution in the UN Security Council for some kind of enforcement action. The UN Security Council is the small body of the United Nations that has the power to order UN members to do things, and it has the responsibility for international peace and security. And so as the body responsible for international peace and security, it is supposed to take action in situations like this. What can it do? Next slide. On the next slide are some of the things it can do through its enforcement powers. So Article 41, we think of really as the article that authorizes actions like sanctions. So that doesn't just mean that the United Nations Security Council can say, we think sanctions are a good idea. Rather, it can order UN member states to impose sanctions on a country. Through Article 42, it can authorize the use of military force, as I described at the beginning of my remarks. So why aren't any of these things happening? As most of you probably know in this room, they're happening because the UN Security Council is a 15-member body. Any decision by the Security Council requires a vote of 9 members, but for substantive decisions, it is subject to a veto by the 5 permanent members. That's the US, UK, France, China, and Russia. And of course, Russia is vetoing any enforcement action that could possibly come out of the Security Council. So the Security Council can't do anything substantive. There is no obligation on Russia to abstain from an action in the United Nations Security Council that may affect its own interests. This isn't a mistake on the part of the drafters. This was intentional. So the UN Charter wasn't trying to avoid power politics. It was really, it was institutionalizing them. And so the fact is that Russia is not obligated to, will not abstain from decisions that affect it. You may have heard that there was a vote in the UN Security Council yesterday to create a special session in the UN General Assembly. That's happening, I believe, right now. It was at least still happening last time I checked. earlier today. So you might be wondering, how in the world did the Security Council manage to pass this resolution on the special session in the General Assembly? Next slide, please. So that happened through something called the Uniting for Peace process. Okay, so back in 1950, the UN General Assembly passed a resolution that included this language. And so the Security Council invoked, after a request from Ukraine, this Uniting for Peace process, through which the General Assembly, this is a plenary body of the United Nations, can hold a special session or can add an item to its agenda if it's still in session in an event that the Security Council is at an impasse because of disagreement among its permanent members. And that's indeed what happened. How did it happen? The vote to invoke the special session in the General Assembly is considered a procedural vote. And as a procedural vote, it's not subject to a veto. So there were 11 votes in favor. Russia, of course, opposed, and then there were 3 abstentions. So what's the point of this special session in the United Nations General Assembly? Well, the General Assembly is a plenary body, so it represents all UN members. All UN members have a delegation in the General Assembly. It doesn't have enforcement power, so it can't force UN members to do anything. It can't impose a requirement that UN members impose sanctions or certainly not military action. So what's the point? The point is, one, that in passing this procedural resolution, the Security Council at least was able to do something. So its members that are going to be prevented from doing any sort of substantive action right now, and there was indeed a veto of a resolution condemning the invasion last week. At least Security Council members can sort of express their condemnation of the action through this way. The resolution from the Security Council wasn't actually necessary, so the General Assembly could have done this without because they're still in session. But the fact that the Security Council did it indicates that there's a desire, of course, on the part of Security Council members to voice their condemnation of what's happening. In the General Assembly itself, we've seen throughout the day that this gives an opportunity for UN members to voice their condemnation of the invasion. It could also produce, beyond condemnation, a call, not a legal requirement, but a way to encourage members to implement what's known as unilateral sanctions, meaning sanctions that states are deciding to implement on their own, as opposed to implementing pursuant to a requirement from a UN Security Council resolution. So this could be a way of encouraging states to engage in support for Ukraine and to implement sanctions against Russia. This is a pretty big deal. So this is the 11th time that such a session has been held. The last time was 1982, according to the UN press office. And so this, I think, goes to some of what Professor Bridgeman was talking about, sort of the naming and shaming and the opportunities through international law, not for direct enforcement, but rather to encourage sort of continued attention on these actions, continued condemnation of the invasion. I'm going to talk about 2 other institutions that are involved here. So the first, continuing on this theme of thinking about the responsibility of Russia as a state, and that's in the International Court of Justice. So this one I wanted to raise, it doesn't actually relate specifically to the prohibition on the use of force, but rather to the Genocide Convention. Next slide. So Ukraine and Russia are both parties to the Genocide Convention, and Article 9 of the Genocide Convention vests jurisdiction in the International Court of Justice over disputes related to the interpretation or application or fulfillment of the convention. And Ukraine filed an application against Russia for under the Genocide Convention a couple of days ago. So this is a pretty interesting move. Ukraine is not claiming that Russia has committed genocide, but rather is using as the basis for its application the fact that Russia is claiming that Ukraine is responsible for genocide. And Ukraine has articulated this as falling under this Article 9 jurisdictional clause. Ukraine is arguing that because Russia is falsely claiming a genocide as the basis of its aggression, that this is a dispute under Article 9 that gives jurisdiction to the court. The court can grant what's called provisional measures. This is like a TRO. It's, temporary measures while the case is pending. And Ukraine has requested as provisional measures that its rights not be subject to a false claim of genocide and not be subjected to another state's military operations on its territory based on a brazen abuse of Article 1 of the Genocide Convention. So again, what's the point of all of this? It's another international body that can potentially rule somewhat soon on the illegality of the Russian invasion. It's quite creative. I haven't been able to figure out yet who are the lawyers who were responsible for this, but Ukraine filed another application against Russia a couple of years ago on the basis of violations of the Terrorist Financing Convention and the Race Discrimination Convention, and those were brought by lawyers in the Washington International Disputes Office of Covington and Burling. So this is, sort of interesting if those of you are thinking about how this relates to what it is that lawyers do in situations like this. So I would say keep a note on what's happening there. Okay, last topic for me, next slide, please, is how we think about the prohibition against the use of force as a prohibition that applies to individuals. So this whole time I've been talking about the responsibility of governments to not use force. Next slide, please. And I'll be quick. The prohibition against aggression is prohibited under the Rome Statute of the International Criminal Court. So the ICJ, International Court of Justice, is a court that hears claims between states and a couple of organs of the United Nations. The International Criminal Court is a criminal court that brings prosecutions against individuals as individuals, and aggression, the use of illegal war, is indeed prohibited. But this is not going to be available as a basis of any enforcement action against Russian officials, and that is because the court has a special regime for how it deals with the crime of aggression. So the court has 4 crimes that it can prosecute: war crimes, crimes against humanity, genocide, and aggression, starting an illegal war. For the other 3, war crimes, crimes against humanity, and genocide, there can be prosecutions where the crime has taken place on the territory of a state party or someone who accepts ad hoc the jurisdiction of the court, where the crime is perpetrated by the national of a state party, or for anyone anywhere if the Security Council refers a situation. Security Council is not going to refer this situation, obviously, so that's off the table. And that's one of the ways for aggression to end up before the court. The only other way for aggression to end up before the court is if the state of the individuals or territory involved have accepted the aggression amendments. Here, Russia and Ukraine are not parties to the Rome Statute at all, so there can't be a prosecution for aggression. There has already been, because Ukraine accepted ad hoc the jurisdiction of the court, there's been what's called a preliminary examination. So early investigation of war crimes and crimes against humanity taking place back to 2014 in Ukraine. And in 2020, so after 6 years, the Office of the Prosecutor of the ICC said that at that time she had finished the preliminary examination and was ready to ask ask the court formally for authorization to proceed to investigation. That would be the formal start of a prosecution, and nothing's happened since then. So the court has stalled out on those prosecutions, which again are not for aggression, but rather for other crimes taking place there. Okay, I've given you a lot here, and I thank you all for your patience and for this opportunity to talk with you.
Thank you. We'll now turn to Elena Chachko.
Thank you very much, Professor Linos. And I'd like to start by adding my thanks to the Miller Institute team and to Tony for putting this together so fast. So I'd like to begin by acknowledging that we are still draped in the fog of war and, if you will, the fog of sanctions. There's a lot we don't know about what is taking place on the ground, what the actual impact of sanctions will be, what clandestine operations might be taking place. So I offer this analysis with humility. I think what we can do now is try to digest these massively consequential developments and try to offer some useful context, and that is what I'll do in my brief remarks. So I'll expand a little bit on some of the points made by Professor Bridgeman, focusing on the US response and particularly the legal options available to the Biden administration to react to the Russian invasion of Ukraine. But I throw in additional frames for analysis that I hope the panelists and the audience will find useful in trying to assess this situation. So I propose to view the US response to the Ukraine crisis as the culmination of gradual, years-long US retreat from large-scale military interventions. And this is the result of the heavy toll of political blowback of the Iraq and Afghanistan wars. We've seen examples of this over the past decade when Gaddafi cracked down on civilians in Libya in 2011, and during the Syrian civil war, the US insisted on a limited role. Leading from behind became the strategy under the Obama administration and has remained so under the Trump administration, with a few exceptions. The United States only recently completed its withdrawal from Afghanistan, and so there's very little appetite for another large-scale military intervention that may bog the US down for years to come and have unanticipated consequences. And this is especially true, as Professor Bridgeman noted, when a nuclear power like Russia is involved and NATO is in the picture, because the potential for escalation is enormously great. So instead of large-scale military interventions, we have seen a gradual turn to more targeted, tailored tools like economic sanctions, cyber operations, and targeted use of military force that does not involve large-scale military operations, but rather relies heavily on aerial warfare and special operations. Those kinds of measures have become the core currencies of US foreign and security policy. And we are seeing this play out in the US response to the Russian invasion of Ukraine. Again, as Professor Bridgeman said, the Biden administration made it abundantly clear from the get-go that there will be no direct large-scale US military intervention. Military response is focused on supporting NATO and international efforts to provide Ukraine with weapons. We've seen an enormous emphasis on economic sanctions that are targeted to achieving very specific goals with respect to Russian leadership and the Russian economy. And we've seen some discussion of potential cyber operations against Russia beneath the use of force threshold. And I'd like to say a few more words about that aspect of the US response that have not been touched upon by my fellow panelists. So I'll start with the sanctions component. The United States has produced an impressive array of sanctions that it has coordinated with other actors, most prominently the European Union, to ensure that sanctions are effective and universal. But the challenge is to create enough pressure on Russian leadership without undermining international markets, particularly the energy markets, and while remembering that there is civilian population in Russia that does not support this war and whose rights need to be considered in the framework of this economic campaign. We've seen the US leverage tried and true authorities provided in the International Economic Emergency Powers Act, also known as AIPA, the Combating America's Adversaries Through Sanctions Act, CATSA, and a slew of executive orders to impose measures against major Russian banks and financial institutions, limiting their access to SWIFT, which is a key international transaction clearinghouse, blocking the assets of Putin and key figures in the Russian elite, and limiting the ability of the Russian central bank to offset the damage wrought by these sanctions through the sizable Russian foreign reserves. We've seen similar measures adopted before with countries like Iran and Venezuela that also face SWIFT restrictions and central bank asset freezes. But what is impressive this time is the speed with which the measures have been put in place and the level of coordination among the key international players. The sanctions were structured to leave room for gradual escalation, so there is a tempo of ongoing pressure. We hear about new sanctions each day. The problem with sanctions, of course, in this case in particular, is that their efficacy may be undermined by information gaps about the actual locations of targeted Russian assets. The United States has formed a task force whose job it is to basically hunt down yachts and jets and real estate owned by sanctioned Russian individuals and entities, but it remains to be seen if this will be effective. And another point to keep in mind is that history has shown that when a nation is sufficiently determined to accomplish something, sanctions rarely succeed in dissuading it from pursuing that path. The hope in this case, presumably, is that sanctions will fuel internal unrest and instability that will in turn put pressure on Putin and associates to retreat. On this front, time will tell. So the second potential major prong of the US response involves various actions that the administration might be able to take in the cyber domain. And we're talking here about cyber operations and utilization of cyber weapons to disrupt Russian networks, to help the Ukrainians slow down various elements of the Russian military presence in the Ukraine, and essentially taxing the Russians for what they're doing in the Ukraine. For the time being, the Biden administration has denied reports that have been surfacing in the news about planning that's currently underway to conduct US cyber operations against Russian networks and infrastructure. At the same time, the president has emphasized in his addresses that the US is ready and willing to launch cyber attacks on Russia, but only if Russia attacks the US first. So the implication is that the United States will not take preemptive sanctions, cyber operations against the Russians unless the United States, its interests, its assets are attacked directly, and it's an important distinction. I'd like to provide some context about the legal authorities that may serve as a basis for potential cyber operations and utilization of cyber weapons by the United States against Russian infrastructure. So what's important to note here is that during the time of the Trump administration, there was a very important development in the US cyber posture with the introduction of the so-called defend forward strategy. And the idea underlying the defend forward strategy is that the United States cannot sit idly by and wait for adversaries like China, like Iran, like Russia to conduct nefarious cyber activities on US networks and against US interests. And so the idea behind Defend Forward is that the US will operate close to the origin of emerging cyber threats, meaning on networks owned and controlled by foreign adversaries, to detect and to prevent those threats from materializing and jeopardizing US interests and assets. That strategy that was announced around 2018 was also accompanied by the introduction of new statutory authorities for the cyber command of the US military to engage in cyber operations on foreign networks. And that authority was incorporated in the National Defense Authorization Act of 2019. And it specifically allows Cybercom to engage in operations to detect and disrupt cyber threats if the president makes certain determinations, including that the source of those threats is one of 4 countries, including Russia, Iran, and North Korea. And so this reform enjoyed bipartisan support. As far as we know, the Biden administration has endorsed Defend Forward, as well as the authorities accompanying it. I should note that alongside the statutory reform that I just mentioned and the new strategy that was announced, President Trump at the time issued a presidential directive that remains classified. That probably elaborates further on exactly what type of authorities relevant US agencies have with respect to cyber operations. We've seen some reports of instances where Defend Forward was put to actual use, including against Russia. For example, around the 2018 US elections, there have been reports about Cybercom and other operations launched by the United States against a Russian internet agency that was responsible for a lot of the disinformation in the election context that was put out on US networks. And that's just one example of how the Defend Forward strategy and the related authorities have been put into use so far. But this conflict creates an opportunity for those authorities to be tested. It creates the risk of mutual escalation, as officials have been quoted as saying, what we can do to the Russians can also do to us. And so when you engage in this kind of cyber warfare, you have to take on the risk that the other party, in this case Russia, will launch similar offensive cyber action against you. And I think that is a major reason why we're seeing so much care and so much hesitancy from the Biden administration in committing to a strong menu of cyber operations in the context of the current conflict in the Ukraine. One last thing that I have to emphasize about the nature of these cyber operations is that, at least according to the administration, what we're talking about here is cyber operations that fall below the threshold of use of force under international law. And there's been a lot of debate in international law circles about how to translate the UN Charter framework and its prohibition on use of force to the cyber domain. What kind of cyber activity against an adversary would cross the threshold outlined in Section 2.4 of the UN Charter prohibiting international use of force? Existing interpretations, such as the Talon Manual, which has been one of the most influential codifications of international law that applies in cyberspace, have emphasized that cyber operations might constitute use of force if they create real-world harm, if their real-world impact is comparable to kinetic strikes, to the use of actual bombs or actual traditional forms of military operations. It seems that to the extent the administration is contemplating this kind of action, it would involve operations that fall below that threshold, interruption of networks, something that has to do with infrastructure without creating actual harm in the physical world, but nothing that in the US administration's interpretation would cross the threshold of use of force. I'll stop here. I'll recognize that there's a lot in this space that we probably don't know, and it's very hard to get credible information about the nature of U.S. cyber operations and the exact scope of Russian cyber warfare against Ukraine that has been going on for a long time now. But this is something important to keep in mind and an important component of the response menu that's available to the United States in the context of this crisis. Thank you.
Thank you so much. We'll turn now to Lindsay Freeman, and we'll run about 10 minutes over because we're 4 panelists and it's just too interesting. If you need to leave at 2, you're very welcome to.
Okay, well, that leads in very well to what I'm going to be talking about, because some of what I'm going to be talking about are the cyber operations that Russia has been waging against Ukraine, not just starting last week, but starting in 2014, when they annexed Crimea and began a conflict in eastern Ukraine that's still been ongoing until this escalation and most recent aggression. At the Human Rights Center, we've been working with some of your classmates here as well on an Article 15 communication to the International Criminal Court, which is similar to an amicus brief, but really but not an official filing, making a recommendation to the prosecutor of the International Criminal Court on different legal theories, or it's a way to share evidence. So it's a way for civil society and lawyers outside the court to engage with the court. And as Sarah mentioned, the ICC has been conducting a preliminary examination in Ukraine since that 2014. So what we've been working on for the last year is looking at cyber attacks that could reach the threshold of an armed conflict and could be charged as war crimes because they have occurred during an armed conflict. This isn't public yet. I mean, talking about it, but I'm not going to get into the details of what incidents we look at or what's in there. That will be soon. But it relates to the topic of disinformation and information warfare as well. In terms of the cyber domain in this conflict, I kind of see 2 areas. One is information warfare, which is exploiting information and communications technologies as part of the armed conflict, and then operations technology warfare, which is going after hacking into systems that actually have some kinetic connection, that are serving functions to people, and in the case of Ukraine and Russia, civilians, because the targets we're looking at are critical infrastructure that are used by civilians and not legitimate military objectives. So the threshold question is one we've examined quite closely. But this is really unique. So in past conflicts, there's been misinformation and disinformation coming out, but the sophistication of Russia's information warfare apparatus is different than anything we've seen before. And Ukraine and other countries as well are doing the same thing and fighting the warfare back. So on all sides, you have this mix of information coming out, which makes it incredibly hard as a war crimes investigator to verify the information, to try and establish the facts of what's actually going on. And last night I was looking through some of Twitter to see if I could find an example, and there were lots, but I don't know if anyone saw what happened on Snake Island in the Black Sea. See heads nodding. So a video was posted that was supposedly, or it was confirmed by President Zelensky that it was accurate, that it had the recording, audio recording. I don't know if I'll say the quote, but with 15 Ukrainian forces talking to a military Russian warship right before getting killed. Soon after that, a Russian-sponsored site put out a video showing those 15, or allegedly those 15 soldiers surrendering and on a bus and getting off onto the ship. So you have these competing videos, and then later Ukraine did put out a press release saying that there was a surrender of different soldiers there. So it's just very muddy waters in knowing what to believe. Here in California, we're not on the ground. We can't, verify what's going on to the degree we would want to. So how do you deal with this situation? And at the Human Rights Center, we have our investigations lab that really focuses on training of these verification techniques. We worked on the Berkeley Protocol on digital open source investigations with the UN Office of the High Commissioner for Human Rights. That is the first document to sort of put out international standards of how you deal with this material. How do you fight disinformation, but also deal with the volume of information, because honestly, it's drinking like a fire from a fire hose right now in terms of how do you actually organize the information, what do you collect, what needs to be preserved, how should it be organized to be used as evidence later in the courtroom. So these are things that are being worked on. And it's still an evolving field. And really in the last few days, a large consortium is developing where open source investigators and lawyers, documenters on the ground, human rights advocates are all working together to sort of design a system where we can better manage this. There's also been some other interesting developments as a result of just the mass amount of disinformation in this conflict. One of which is the US is declassifying a lot of information in a way we've never seen before. Other governments are doing this as well, just to establish what the facts are. So that's really interesting because we're getting access to information that usually a government like the US would not share publicly. Also, this is an issue for the technology companies themselves who have been trying to deal with content moderation issues for a very long time, but particularly in conflict areas and particularly in a situation like this, they have a lot of challenging decisions to make about what to do with that content, whether they take it down, whether they deprioritize it, but how do you do it at that capacity, at scale? There've been artificial intelligence programs or algorithms developed to help with that, but that can also have the backlash or a problem of taking down evidence really quickly that is actually, evidence, content that's evidence, from the internet before war crimes investigators have a chance to preserve it and to be able to use it. So there's all these conflicting interests that we're sort of trying to work through. But I will say sort of in the last year, we had the January 6th insurrection, the Myanmar coup, leaving Afghanistan, and now this, all these sort of rapid response events. And there's been significant improvement, I would say, in the last year in how quickly people are responding, how coordinated the effort is, and also just having the databases and infrastructure built in so that we can actually intake information in a way that makes sense and is going to make it usable in the future. Since we're at time, I'll maybe leave it there.
Thank you so much. Let's do one quick round of questions. I have a couple from the chat that I'm going to read out loud. If people want to ask one or two questions, the lucky person will get Ms. Mendocino's microphone. Let me just ask some general questions here. One question we have is, what is the responsibility of corporations to act either in content moderation or in other ways to curb Russian disinformation? We have questions about how just war is waged in the cyber age. And we have questions about how this is. Thank you. Thank you for that. I'll repeat the questions as I didn't do that properly. So questions about how we wage just war in the internet age, what the duties are of US companies to take steps to fight disinformation, and specific legal mechanisms that are available to Ukraine under claims of genocide, or to specific prohibitions on the sale of weapons to states involved in these conflicts. So if there are any questions from the floor, we'll here.
I have a quick question. Hi, my name is Amanda Colding. I'm from South Orange, New Jersey, and I'm a 1L. I guess I'm just curious about I am curious about the impact on the rest of the world, the impact on people in the Ukraine, but I'm also curious about the impact on students, people who are refugees, asylum seekers, specifically from African countries. Thanks.
So whoever wants to give a minute or two of closing remarks in response to any of these questions.
Sure, I'm happy to jump in. Maybe I'll just speak quickly to two of the questions that were raised. So one on the Genocide Convention, it doesn't look like, other than the claim concerning the claims of genocide on the part of Russia, that there is at this point an argument to be made under the Genocide Convention for what Russia is doing to Ukraine. So the definition of genocide is quite limited. And so again, at this point, as far as we know, the attacks, the particular war crimes, crimes against humanity, I don't think there's been an effort to articulate those as genocide itself. There's a question about the prohibition on the sale of weapons to parties to the conflict. I know others in the group are far more expert in sanctions than I am, but I did just want to highlight one difference. So some of you might recall, a lot of debate about support from the United States and other countries for Syrian rebels, so arming of Syrian rebels, financing of Syrian rebels, and the provision of support for Ukraine, whether through provision of weapons, provision of money, is a quite different matter because of the difference between helping out a state that is engaged in a self-defense use of force and helping out an armed group that is not the government of that state. So that set of questions that some of you might be familiar with around assistance to rebels in Syria, it doesn't apply here. That also, I think, raises a really interesting question in international law, or theme in international law, which is the difference in treatment between state-to-state war and wars like this of self-defense on the part of Ukraine and what's known as non-international armed conflict. And there are different sets of rules in some cases that govern these. And also, I think the public response it's different here, right, from a number of civil wars around the world because of sort of the preeminence in our minds and in our law of what it means when one state invades another.
I can just add on briefly to that.
Address your question a bit. I'm not sure it will get to all the communities that you mentioned, but certainly in the work we're doing in the investigations lab at the Human Rights Center, on many of our different projects, we have students who are from those conflict areas, including Ukraine. So it has been a really interesting experience over the last week in how to deal with that, because it is a very emotional. It turns this, gives it this emotional element in working on the cases. And so because of that, at the Human Rights Center, we've developed a lot on resiliency, which is a huge focus in secondary trauma, which I think is particularly acute in our current information environment where so much information is coming at us. And certainly I've seen the response from so many people of just wanting to do something, just wanting to jump in there. And sort of in terms of that, I've seen it work both ways. I think for some Ukrainians, and we've been in touch with people in Ukraine, some Ukrainians who have recently left, students here, they really want to work on the situation. I mean, they feel passionately. That's what helps them feel grounded, that they're doing something. They don't want to just be sitting there. And for some, it's too emotional. Understandably, it's hard, and you're going to be, it's going to be too hard to work on. And so we really like to leave it open to the student's choice of what they want to do. At any time they can stop working on something, but also giving the opportunity to those from situation countries who want to assist in the investigation is really important. And the effort I mentioned, the consortium that sort of developed, is very Ukrainian NGO led. So there's lots of people who are very active in this who are helping with the effort.
So given that we're getting clear technical signals to end our event, thank you very much for coming here, and please thank our panelists for a fabulous discussion.